alleged confession. In fact, the only case law that I have found that indicates that mental health short of mania should not be considered when determining whether a statement was given freely and voluntarily. Right, this matter is set for the state's motion in limine regarding the diminished capacity or mental health issues of the defendant. I've read the motion and the accompanying case law. Ms. Pinnell?
Your Honor, the state's position is laid out in the motion, and I believe that the case that the state cited, just for the record, is Chestnut v. State, 538 Southern 2nd, 820 from the Supreme Court from 1989. I believe that case is directly on point with the state's position. In this particular case, there has been a plea of not guilty entered by the defendant. There has been no litigation or no filings or any indication that the defense was going to rely on an insanity defense in this particular case. So based upon the case law, the state's position is that any evidence about the defendant's mental health status, diminished capacity, or any evidence of Baker Acts would be irrelevant and would mislead the jury in this particular case. The state would be asking the court to exclude that type of evidence.
Thank you.
Yes, Judge. And I have one case for the court, if I may approach. It's Falemo v. State, 930 Southern 2nd, 821, a 50 CA case, which I provided to the state previously this morning.
Thank you.
Essentially, Judge, defense is arguing, we're not asking for diminished capacity specifically itself to be able to be introduced and be a feature of the case. However, based off the court's ruling as with the motion to suppress, as well as the likely information that's going to come up, the fact that Mr. Todt was initially Baker Acted under, came to the hospital seen by a doctor in all those proceedings and met the criteria for Baker Act, defense feels that information as to the mental capacity, not necessarily specifically diminished capacity or saying insanity or McNaughton, should be admissible in this case to go towards the theory of defense as well as the capacity to understand it. Ultimately, the jury's going to likely get the jury instruction that a statement purported to be made by the defendant has been put before you. You have to determine the freely and voluntariness of that statement. So the Baker Act capacity and any mental capacity based off of that, defense argues would be relevant for the jury to determine the voluntariness of that statement, not saying that it's insanity, not saying that it's specifically diminished capacity, but to the freely and voluntariness of that statement, since with the court's ruling, the initial first, quote-unquote, first statement isn't coming in, but statements 2 and 3 would be, where they still mention, even in those statements, him being in the hospital, him being under the care of the doctor and things of that nature, and asking him about the Benadryl and things of that nature. So defense's argument and position is that in that limited capacity, it should be admissible and should be able to come in.
Okay, let me unpack the argument. It's the defense's position that they are not going to be raising an issue of diminished capacity regarding the mens rea, the intent, and the specific intent as alleged in the offense. It's the defense's contention that they are wishing to raise the issue regarding the voluntariness and the credibility that the finder of fact is to assign to the subsequent confessions. The court is aware of the case law that indicates that while voluntary intoxication of over-the-counter prescription medications cannot be considered as to the admissibility of a statement, it can be considered by a trier of fact in determining the credibility of those statements. I am unaware of any case law that supports the defense's contention that an argument of diminished capacity or suicidal ideations in any way affects the determination of a trier of fact's determination as to whether statements are credible or not credible, or what weight to give to those statements. Have you found any case law that supports that the diminished capacity can be used for that purpose?
Essentially, it goes to state of mind. In the 50 CA case which I provided, the court is essentially what that is saying, that it would be admissible to determine state of mind at the time of the statement.
Wasn't the difference that in Filomeno, the state of mind was relevant to the issue of self-defense, which occurred at the time of the offense? This would be the state of mind at the time later after the offense regarding the statement. Is that
Yes,
the defense's contention? All right, thank you. Ms. Pinnell, response to that argument?
Yes, Your Honor, I believe that the case law is clear. As the court indicated, there is case law indicating voluntary intoxication of over-the-counter drugs could potentially be considered by a jury in determining whether the statement made by a defendant is voluntary or not.
And so the record's clear. That's Reiger-Tink v. State. That's 193 Southern 3rd 846, a Supreme Court case which references a very old Supreme Court case, I believe from 1913, which stands for the proposition that a finder of fact may consider voluntary intoxication for the sole purpose of determining the weight and credibility to be given to a confession. The case that's referenced is the
Correct, Your Honor.
Lindsay v. State case. That's 66 Florida 341, a 1913 case.
Correct, Your
It
Honor.
appears that that is still good law.
As far as the state's aware, yes, Your Honor.
All right.
I believe that evidence can be presented by the defense and that the defendant did take Benadryl according to the defendant's own statement. They have an expert witness that was listed that can testify as to the effects of Benadryl.
Dr. Scully Danziger is anticipated as a toxicologist to testify to that, yes?
Correct, Your Honor. I don't believe that limiting the defense from indicating that the defendant was Baker-acted or had any type of diminished mental capacity would be prohibiting them from presenting that evidence. And I think discussion of Baker Acts and diminished mental capacity and mental health issues would cloud the issues for the jury and mislead the jury in this particular case. I believe that the defense can still put on the defense it intends to without utilizing that information.
Any additional case law or argument from the defense as the state's points?
No additional case law, Judge. Just I guess the additional argument would be that during the Baker Act and during the treatment, during that hospitalization, there's the loprazolam injections that are occurring during that time while he's still being treated, which could affect any potential mental capacity or not. I know the state has their expert. We have ours in terms of the effect or not of Benadryl, loprazolam, and all of that. So I guess essentially the defense's argument is that no, we're not intending to make it a feature of the trial, but it's going to come up. It's going to become relevant. I know even when we were talking about the jury questionnaires about the language about potential Baker Acts and the mental health, it's going to be brought up. And so defense's position is that it won't become a feature of the trial, but it does go to the theory of defense, and it should be relevant and admissible to go towards state of mind as well as the voluntariness or not of the statement and the admissibility in that regard for the jury to be able to consider.
All right, thank you.
The court have the admitting physicians paperwork.
For today.
This is the admitting physician. But there's a physician that will keep it when they call. Not when they got one.
And Judge, I know that we've, litigated various parts of it. I know we've talked about the admitting physician and his observations and indications that caused him to make the finding that he felt the placing a Baker Act hold was necessary and relevant, the ideations that he observed and things of that nature. So that will ultimately go to all of that in terms of the chain of events and the sequence to lead to here and now.
Thank you. The court has been unable to find any case law that Florida's motion to exclude testimony of Mr. Todt's alleged Baker Act or Baker Act recommendation after the events at the time of his arrest or the ideations referred to should be allowed in the guilt phase. In fact, the totality of the cases before the court indicate that unless it, in the very limited issue in the Filomeno case where it was necessary that there be a testimony from a mental health capacity regarding fight or flight at the time of the event where the defendant was claiming self-defense and the defendant's state of mind at the time of the offense, which was before the jury for their consideration, was necessary for the trier of fact to make that determination. In this case, the sole basis for the use of that information would be for a trier of fact to make determinations regarding the weight and credibility of the defendant's confessions to law enforcement. The Spencer case contemplated a little different circumstance where it was contemplated that a dissociative state at the time of the offense should have been raised by defense counsel. The Florida Supreme Court indicated that introduction of a mental condition is simply too misleading to be allowed in the guilt phase of a trial, as it is a difficult concept. While intoxication is something within the grasp of an ordinary juror, the dissociative state, absent expert testimony and very specific circumstances, are outside of the grasp of a particular juror, and it has been understood for quite some time that evidence of most mental conditions falling short of mania or insanity at the time of the offense are not to be considered in the trial, in the guilt phase, by the trier of fact. I think it's well established. I found no exception for courts to be allowed to consider that mental state for credibility determinations of confessions. The court finds it to be clear that the issue of diminished capacity is inadmissible in the state of Florida in the guilt phase, and the court is going to grant the state's motion in limine. There is case law that supports that any medications that Mr. Todt was on at the time of his confessions should be considered if they are established by competent evidence by the trier of fact to make determinations as to the weight and credibility of those confessions. The defense will be barred from referencing Mr. Todt's Baker Act and suicidal ideations and any dissociative state or many mental conditions in openings pending a determination by the court that those issues have become relevant.
You said an opening, correct, Judge?
Right, and I don't know what the evidence is going to show in this case, and I don't know whether Mr. Todt's mental health after his contact with law enforcement what, if any, relevance that would have. The defense is free to make an argument that, based on the evidence presented, some door has been opened or some circumstance has been put forth before the jury that makes those issues relevant. But the pretrial ruling is going to be in line with Spencer v. State. And for the record, that's 842 Southern 2nd 52. And the Chestnut case, which is 538 Southern 2nd 820. I'd like to take the remainder of the time to finalize the proposed questionnaire from the jury. There were some issues on the questionnaire that the court had reserved ruling on, depending on the finalization of this court hearing.
Your Honor, may I raise one issue that's dangling about the diminished capacity?
Yes, sir.
And that is that I presume that the court will be instructing the jury that a statement purported to have been made by the defendant has been put before you, and you will have the right to decide that the circumstances of the statement should be believed or not. Paraphrasing here.
Of course, I'm familiar with the standard jury instruction, which indicates to the jury that they should consider the circumstances in which he gave it, and if they feel that he was compelled or for any reason the statement was not freely and voluntarily made, they should disregard it. So at defense request, if that is evidence that's elicited, the court would be inclined to give that instruction to the jury.
And I'm also wondering whether the court's ruling prohibits us then from putting on an expert about the condition of the client when the statement was made.
The condition of the client with regards to the intoxication from a substance, I think, is fair game. I've seen no evidence whatsoever that supports that the court should properly consider mental health conditions when determining the validity of a alleged confession. In fact, the only case law that I have found that indicates that mental health short of mania should not be considered when determining whether a statement was given freely and voluntarily, or freely and knowingly. But it may be an issue as to whether the statement was given voluntarily. However, the courts have only extended that to evidence where there is coercion or undue tactics with law enforcement. So if there's any additional case law that's out there that supports the defense's desire to present a witness to testify to Mr. Todt's mental status in fulfilling the jury's role to make a determination as to the credibility of his statements, I'm receptive to that, but I've been unaware to find any support for that argument.
There's also the involuntary intoxication, and that the hospital records show that he was being intravenous injections of lorazepam. And so that was at the same time that the questioning stage took place.
Okay, that may depend on whether those injections were pursuant to medical personnel and at the prescription prescribed by a doctor or in excess of that. I don't have the answers to that question, so I don't know whether that will be relevant or not.
Thank you for hearing.
Yes, sir, Mr. Wesley.
You were asking about the,
Questionnaire for the jury. I
I printed copies, Judge, and I know the state has a stipulation for the proposed statement. I put it on this one just because I had it on the same document, if I can approach it.
All right, thanks. Have the parties agreed on a proposed statement?
Yes, Judge, it is a signed stipulation.
Yes, Your Honor, there's a signed stipulation that I provided to Madam Clerk.
All right,
I
thank
do
you.
have an extra copy if the court wishes to see it.
Somebody can give me a copy, I'd be happy. Thanks. Yes, please.
So the top one is the jury selection, and we are talking about the questions that the court was gonna ask, and I put the proposed statement on there, and the second one are the questions that we needed to finish hashing out. Based on the ruling today.
All right, thank you. As to questions 1 through 6 for the proposed jury questionnaire, as well as the statement that is stipulated to, Okay, the proposed statement is different than the,
Right. So I signed the stipulation today, so that proposed statement could essentially be
got it,
changed to the stipulated one and deleted from there.
understood. All right, so the parties are in agreement that the jury questionnaire will include, as a result of any media coverage you have seen or heard, have you formed an opinion in this case? 2, does anyone have any strong feelings of religious beliefs? 3,
Your Honor, I'm going to stop you for 1 second. The state is not in agreement with all of these.
Okay.
I'm in agreement with 1. I believe 2 through 6 were included in a previous questionnaire that the court denied and indicated that the court would ask a pre-qualifying question similar to, does anybody have any religious beliefs that would cause them to hold others who have different views, hold that against them or not? At least that's what I had written down.
My understanding, Judge, from the last hearing we were doing, the questions was, and that's why I put them on the one that's titled court questions, was that the court was going to ask these as to pre-qualification, and then based off of the answers, if an individual voir dire was needed. So I know they still have lines, but essentially the court would ask them as raising the hand questions, and I used the language that was on the previous one because of listening to the audio. That was my interpretation of what the court was saying you were going to do, but I might have
the second,
misunderstood. That's why I made 2 documents.
I think the second inquiry may open up Pandora's box. It's pretty general. Does anyone have any strong feelings of religious beliefs?
I mean, if we did, it would affect their verdict, we could add that language, but.
Purpose of voir dire is to indicate or to highlight and bring to light any life experiences or deeply held beliefs that could cause a person difficulty remaining fair and impartial. Court does generally get into the discussion of hesitation of sitting in judgment of another human being based on a religious or strongly held moral belief. I don't necessarily think that, I think paragraph 2 is going to elicit lengthy responses or from some folks, but I don't find it objectionable, so. Paragraph 3 was discussed. Does anyone believe that one form of religion or religious beliefs are superior to another? I think that was within the purview of the court's previous order. I think count 4 is the or paragraph 4 is the necessary follow-up question to count 3. Count 5 is similar. I think paragraph 6 appears to be repetitive to the court. Not sure.
To me, Judge, 6 was the follow-up to 5, kind of how in 4 I did the follow-up to 3, since it was specific to faith, and does that.
How are paragraphs 3 and 5 materially different?
One specifically to religion and some to faith. Some people view religion and faith differently and separately. The spiritual versus the, I guess, emotional or natural state.
State? Any feelings one way or the other?
Your Honor, I think that they can be combined into one, if the court is going to ask it. I, I think that,
Ms. Smith, any objection to paragraph 3 reading, does anyone believe that one form of religion, comma, religious beliefs, comma, or a specific faith?
No objection.
Purposes of brevity, I think that's going to be better. So the court will strike paragraphs 5 and 6 of the proposed questionnaire to potential jurors. Paragraph 3 will read, does anyone believe that one form of religion, comma, religious beliefs, comma, or a specific faith is, I guess, superior to another?
Does that mean in paragraph 4, we would also add the
Yes, please.
more specific?
Rel- Of religion, comma, religious beliefs, comma, or a specific faith. All right, the court did reserve on the original jury questionnaire, paragraphs 2, 3, and 4, which appear to be memorialized in this copy as proposed 1, 2, and 3. Paragraph 1 on the second page, do you have any close friends or family that have been affected by mental health? For what purpose is the defense vetting that question to the jury?
Different people, different nationalities and genders and races have different feelings in terms of mental health, the existence or non-existence of it. So it's the defense's position that it will be relevant to determine if they feel that mental health could play into any parts of this case, whether that be from defense or from the state's presentation of the case.
State?
they will be objecting based upon the ruling in the motion in limine.
Other than Mr. Todt's Baker Act recommendation and his self-reported ideations, suicidal ideations and voices, is there any additional evidence that is known to the parties that's going to raise the issue of mental health?
Additionally, and I guess it might go more so in all candor towards the religion aspect than mental health, but in terms of Megan's mental status, mental capacity, her thoughts and feelings on holistic versus natural medicine and things like that, it might be more religion than mental health, but it could maybe go both ways depending on how the parties view it.
And what determination for the jury is going to be affected by Ms. Todt's alleged mental health?
I don't know if it might play into or factor into their feeling or weighing of the evidence through the presentation of the evidence and the case. I know the court did allow the questions in terms of suicide and personal choices on suicide, but sometimes suicide is based off of mental health, sometimes it's based off of the religious or non-religious beliefs. I guess that's kind of where defense is.
Have a moment, let's go, counsel.
Sure.
And that as well, in this case, the death penalty was taken off the table, at least according to the notice, due to potential mental health of the client as well. So defense's position is that mental health might be relevant in some capacity for the jury to consider. The general way in which it's presented or asked of them, we'll leave to the court, but we think it should be asked in some capacity.
Okay.
The jury isn't going to be deciding the penalty in this case if the defendant is found guilty. The mental health of the defendant is absolutely relevant in a penalty phase when death penalty is being considered. That is not the case, and therefore the state would be objecting and inquiring of the jurors.
As to the issue raised that if there was admissible evidence, I'm not exactly sure, and I'm not going to ask the defense to lay out their strategy in this case. I'm not sure how this would be brought before the jury, but if Ms. Todt's mental health weren't a relevant issue in this case,
I don't believe so. I don't know how the defense seeks to enter evidence regarding that. I don't believe that it's relevant to the trial, and I am objecting to these 3 questions being asked.
all right, thank you. As to question 1, the court has to give the defense a wide berth in vetting preconceived notions and how that in any way could affect a potential juror's determination of bias or inability to remain impartial based on their life experiences. I'm going to allow question 1 to be included in the questions to potential initial questions to the jurors for their consideration. As far as question 2, any additional argument from defense? This regards involuntary commitment.
And I know it's kind of in bold after this question, Judge. I know we had talked about at the last hearing, the court maybe giving a general statement in regards to that. I understand the court's ruling in terms of the state's motion. Maybe if the court were to give some kind of general language regarding Baker Act, the question might not be needed. And then maybe question 2 could be eliminated, but maybe question 3 would be used.
I'm still unclear as to the relevance of Mr. Todt's Baker Act weeks after the alleged criminal offense, and why that should be brought before the jury for their consideration in the guilt phase. I am going to make a ruling that comports with the court's ruling in the motion in limine, and the court's going to disallow paragraph 2 from being presented to the potential jurors in a jury questionnaire. As to paragraph 3, along the lines of paragraph 1, the court is going to allow that questionnaire to be put forth for the potential jurors. As to paragraph 4,
I mean, I believe 4 and 5 were the ones that the court previously had allowed, which is why I separated them.
agreed. I think there's going to be, I suspect there will be an argument put forth of suicide in this case that does not relate to Mr. Todt. So the court finds that the defense should be able to vet that very personal event to highlight any prior experiences by a potential juror that could cause them difficulty in remaining fair and impartial.
And so then I guess in terms of the language of the Baker Act, based off the court's ruling, would the court not be providing or?
No, absent that becoming at all relevant for the trier of fact, the defense is not to discuss the Baker Act or what that means.
And then one last question, Judge, in terms of the questionnaire, how does the court want it prepared? Do you want it pleading style, just these questions typed with no heading? Does the court have a preference?
I do not. I will disseminate to 50 jurors on Monday morning the document. I think that probably the lines for a response might need to be added to give them a reasonable. The older I get, the farther away I have to hold these documents from my eyes, so you may want to give them a reasonable amount of real estate to write on should they choose to respond to the questionnaires. I'm not sure what we're going to do with that information. Is that going to be collected from the potential jurors and then disseminated to the parties for their consideration prior to the court conducting its pre-qualification regarding publicity? And it looks like these questions are included, so it's going to take the jurors
I don't
probably.
know if this is something that can be given to juror services, like when they, you know how when we get the panel with the questions, if this is something that will be, kind of come up with the packet.
Sure.
If it's easier for the court, like defense can make the copies if the court wants me to fix the document and send it to Ms. Hafner to be sent to jury. That's kind of the logistics I wanted to ask the court about, how the court want it handled and created.
I've not before used jury questionnaires, so
And
somewhat uncharted territory for the court.
I think it's also, is somebody going to copy it so everybody has a copy? Because if they handwrite it, I'm assuming they're not going to write the same thing 4 times, so somebody's going to need to copy it.
All right. Whatever form it's in needs to have the number of the juror at the top of the document. I don't want to use the juror's name, so their juror badge number, they should be labeled sequentially, meaning 1 through 50, 50 through 100, 100 through 150. That's the request that the court has made of jury services. So.
The seat and the badge number will be similar.
Not the seat, the badge number. Yes. So, yes.
For the first.
I understand your question. Yes. Yes, ma'am.
And with the heading, just to make it correct, if we could put State of Florida versus Anthony Todt in the case number?
So how to do it like a pleading.
I would. The case number and a place for them to write their badge number so we can identify it, and I'll do my best to assist the parties with copies. I'll share this unique request with the jury services folks today.
And I believe they were going to come through the walkthrough, so maybe even during that, if we can inquire.
That's why I was going to have the walkthrough.
Maybe somebody can scan and,
I'm sure we'll be able to sort out that logistical consideration. Oh, they're here. All right, so they've heard the request, and perhaps at the walkthrough we can put our heads together as far as how the jury questionnaire will happen and whether they've experienced that request in the past. No.
And then in terms of the question that the court is going to ask, I can make the edits that the court indicated today and send that to Ms. Hafner, or does the court want to type it themselves? I don't.
No, just send a copy over to the state and then submit that to Ms. Hafner, and we will make a copy and be ready to go on Monday morning. All right, while we're all together, I'd like to take just a quick opportunity to verify that there are no unresolved pretrial motions that have yet to receive a ruling from the court.
the state is not aware.
Okay. All right, just so the record's clear, the court has resolved the motion to exclude evidence of collateral crimes filed by the defense. The court has resolved the motion in limine to prohibit mention at trial to the translated word of the German word Todt filed by the defense. The court has resolved the motion to prohibit introduction of cadaver photos of the deceased victims, and those photographs have been limited. At a previous hearing, the motion for individual and sequestered voir dire, that issue has been resolved by the court. Motion in limine on trial procedures has been agreed upon and resolved by the court. Motion in limine to prohibit the reference to federal agents has been resolved by the court. Motion for limited questionnaire of jurors we've just discussed. The motion to suppress the defendant's January 13th, 2020 and January 15th, 2020 statements has been resolved by written order. The motion to edit the January 13th, 2020 and January 15th, 2020 statements to exclude issues excluded by motion in limine has been resolved. Have those edits been made, Ms. Pinnell? References to?
I have not. That is something that I was going to do today. I did discuss.
Okay. My recollection from the order was that the portion of Mr. Todt's discussions that referenced the federal case were going to be redacted. All right, thank you. Motion to exclude evidence, that one we've talked about. Motion in limine to prohibit reference to the trial testimony to the victim's murder or to the murder scene. I think you guys got a ruling on that, and the motion to prohibit shackling or other restraint at trial has been resolved. Those are all the pretrial motions that I am aware of. Defense, any additional pretrial motions?
Not that I can think of it at this time, Judge.
Ms. Pennell?
Not that I am aware of.
All right, thank you. All right, we will begin with jury selection on Monday morning at 9 o'clock. I'll ask the parties to be here at 8:30, and we can resolve any last-minute issues at that time.
One question, Judge, and I can email Ms. Hafner if it's easier. Defense wanted to ask about if there was going to be any video link or any streaming that the court is aware of that could be provided to any family of Mr. Todt or anyone.
I've asked our tech people to be present at our little walkthrough, and maybe we'll defer to their expertise when they get here.
Thank you, Judge.
All right, thank you. I think that concludes the basis for today's hearing. Anything further from defense?
One thing,
Yes, sir, Mr. Wesley.
for the edification of security and other court people, Destiny Green is a member of our office staff.
Ms. Green?
She's a third-year student at FAMU and will be graduating soon and will be involved a lot with us with documents and others. So-
Is she a certified legal intern?
Sorry?
Is she a certified legal intern? No?
Because we made her do real work.
All right. Absent any objection, the court would permit Ms. Green to sit on the bench up in front of the bar. Any objection?
No.
All right. Ms. Green, you're welcome to sit up here at the bench behind counsel if you wish to hear some of the discussions at counsel table.
I thought she might sit on that bench.
Would you prefer she sit up here? She's welcome to. I have welcomed interns in the
She hasn't
past.
taken that course yet.
Okay. All right, thanks.
Thank you,
All right, thank you. That's going to conclude our hearing.
And then obviously the walkthrough.